My name is Michael McCurdy, and I am the host for tonight's event at the California State Library. I am a librarian with the Witkin State Law Library, part of the California State Library. Before I introduce our guest speaker, I just want to briefly talk about the State Law Library. For anyone who is not familiar with us tonight, the State Law Library provides free legal research assistance to anyone that needs it, regardless of where you live. Our specialty is in historical California legislative and regulatory research. And so if you need any assistance finding historical legislative bills, statutes, old regulations, or you have any other type of free legal research needs, please let us know. Don't hesitate to reach out to us. Our extensive collection of international, federal, and all 50 state legislation also allows us to help users to conduct a wide variety of legal research outside of California's borders. The State Library also has a government publications section that that collects state and federal agency reports, maps, and a plethora of other government documents that are useful to legal researchers, especially those interested in water. Let's see. So let's see here. One moment. See. Sorry about that. So I have just a little bit of housekeeping to cover before we get started. So we have a co-host tonight, Mona Robinson, a librarian from the State Library's Information Services section, and she'll be monitoring the Q&A window throughout the talk for any questions you may have for our guest speaker. And then she'll read those questions aloud during the Q&A session at the end of the presentation. If you run into any technical difficulties during the presentation, please put those in the Q&A window, and we'll try to help you as best we can. The chat feature will be turned off for this event, but we will be using it to post a few library-related links for you. Additionally, live transcription is enabled tonight, so if you'd like to see captions, please click the CC icon in the toolbar to show subtitles. And lastly, this talk will be recorded. To get notified about the recording for this event and to stay up to date on the Law Library's happenings, please subscribe to our quarterly e-newsletter on the State Library's website. And Mona, our co-host, will be adding a few links to the library chat window that you may find useful. They'll also be listed in the chat at the end of the Q&A session. So the first link is for the State Library's homepage. The second link is to sign up for the State Library's various mailing lists and newsletters. And the last link is for our Ask a Librarian reference platform, where you can submit research questions to the library on any topic, not just the law. For any questions you have for our guest speaker today, please enter those in the Q&A chat window. And then events like this one would not be possible without the help of the California State Library Foundation. And so a big thank you to them for helping put on this event. Now that housekeeping is out of the way, let's get on to the main event. I'm going to shortly stop my video, stop sharing. All right. So today, our guest speaker is Professor Jennifer Harder, a professor at the University of the Pacific McGeorge School of Law in Sacramento, where she teaches courses in water, environmental, and administrative law. She also serves as co-director of McGeorge's Water and Environmental Law Concentration and as McGeorge's faculty director for online learning. Professor Harder is co-author of the Water Law textbook, Cases and Materials on Water Law, 10th edition, and her research focuses on integration of classic water rights principles into contemporary regulatory systems, water and growth, and issues of water justice. Please give a warm virtual welcome to Professor Harder.
Thank you so much, Michael, and welcome to all of you joining us here this evening. I'd like to express my appreciation to Witkin State Law Library for the invitation to come speak to you this evening about water and drought in California. Allow me the opportunity to talk about one of my favorite topics and one that I think is of critical importance to everyone in California and in the West today. So to start my talk, I wanted to talk a little bit about the nature of water. because the nature of water governs, controls, directs all of the rules and principles that we use to allocate water. So we want to think about some of its essential attributes. Water is unique as a natural resource. It's vital for human health. We need to drink water to stay alive for health and safety reasons. It's vital for homes and businesses for reasons other than health and safety, supports a robust economy. It's vital for the environment, fish, wildlife, and habitat. It's unique in that it's found both on the surface and underground, and it moves both on the surface through rivers, lakes, streams, and underground in groundwater basins. Another reason that water is a unique natural resource is that the available quantity varies by location, year, and season. Now, this is a really important attribute to pay attention to because it drives a lot of our laws and policies around water. So let's start by talking a little bit about the way in which water varies by geographic location, geographic scarcity of water. And we can see this at the national scale. If you take a look at this map of the United States, you can see that the eastern portion of the United States on the right is mostly green, and the western portion of the United States is mostly in this yellow and orange and brown colors. The colors represent average annual precipitation, average annual rain and snow. They say that west of the 100th meridian, there isn't enough rain and snow to support agriculture without artificial irrigation on an annual basis. East of the 100th meridian, there's enough rain and snow to support our agriculture with just natural precipitation, rain. You don't need that artificial irrigation. And what do I mean by artificial irrigation? I mean storing water in reservoirs in wet seasons and wet years and releasing it in dry years. You can see here on the map, there's actually a reference to something called the 98th meridian. These are imaginary lines of longitude that separate these climate regions in the US. And the scientists are saying that because of climate change, the dry areas in the United States are actually moving eastward. So we're starting to get that dry area and needing artificial irrigation farther and farther east as time goes on. Now, this geography has had a large influence on our water right doctrines. And so in the eastern part of the United States, our water right laws are very different than they are in the West. And so I'm going to talk tonight a little bit about both of them. You see the same scarcity play out in California. On the left-hand side of your screen, you see a map of California. The yellows, reds, and oranges represent the dry areas where there's little precipitation, annual precipitation, the blue and purple and green areas where there's more. So you can see that there are portions of California that do get a great deal of rain and snow and other portions that just don't. Now, what's interesting about California is that if you look at the map on the right side of the screen, that's a map of the population distribution in California. The red spots are where the people live. So if you were able to overlay the two maps, and my technology isn't fancy enough to do that, but if you could, you would see that most of the people live in the areas where there isn't a lot of water. And so because of that geographic mismatch, in California, we have to get the water to where the people are. Now, there's a couple of other kinds of scarcity of water in California that are important. One is scarcity on an annual basis. You see here on the left, a chart of drought years in the last 22 years. The years that are yellow and orange and red are the ones in which there has been very dry conditions, little rain and snow, and the ones in white is where it's rained. So you can see that drought is really a normal condition in California. We have experienced drought in cycles over and over again throughout the history of the state. You see a little snapshot of it here. Climate change, of course, is exacerbating the impacts of drought. On the right-hand side of the screen, you see charts of seasonal scarcity. So even in a non-drought year, you get more rain and snow in the winter and spring. In the spring, you get the snow melt. So you get a lot of water in our rivers. In the summer and fall, you get much less, and you can see the patterns here for both Sacramento and San Diego. So our laws in California have had to react to this geographic, annual, and seasonal scarcity of water. Now, that scarcity, of course, has led to drought conditions. We're in a period of scarcity over an extended period of time. Here's the United States Drought Monitor as of a couple weeks ago, October 18. You can see the dark red areas are the areas experiencing extreme drought, and the purple areas exceptional drought. So you see it spread over much of the West and not quite so much in the East, although it's creeping eastward. If we were to focus in on California, you can see that the extreme dry areas go right through the middle of the state, with the severe dry areas, the severe drought occurring in the southern part of the Central Valley in California. So what was our solution in the Western United States and in California to addressing these several kinds of scarcity? We store water in reservoirs and we build pipelines to move that water. The gentleman you see on the screen here is a famous historical person, John Wesley Powell. John Wesley Powell wrote a famous report called the Report on the Arid Lands, in which John Wesley Powell explained about this kind of scarcity, and that in order for people to live in the West, we would have to build reservoirs. We would have to capture water in the wet seasons and the wet years and release it in the dry seasons and dry years for people to live here. And that's exactly what we did. We built a series of reservoirs to move water around the state. And these reservoirs were constructed by the federal government, the state government, and by local governments. So the federal project is called the Central Valley Project. It moves water from Shasta Reservoir, Lake Shasta in the north, through the Sacramento River, down through the Delta. It also moves water from Friant Dam in the more central southern portion of California, releases it into the San Joaquin River and back up, and both of those facilities meet in the Delta. The Central Valley Project also has a number of other important facilities: Folsom Reservoir, New Melones Reservoir, San Luis Reservoir, and others. Then there's the State Water Project, which captures water at Lake Oroville, which it captures the headwaters of the Feather River, releases that water into the Feather River, which then is a tributary to the Sacramento River, where it comes downstream. They share facilities at San Luis in the Delta, and then they move water into the California Aqueduct and down to Southern California. Of course, there's a lot more to the State Water Project. Those are some of its main features. Both of these projects meet in the Delta, which is a place of special ecological and cultural significance in California, as well as agricultural production. And so there's a lot, as you may know from watching the news, a lot of water issues that come up around Delta issues. There are also a number of local projects, including projects that move water from the foothills, Pardee Reservoir, through the McElhenney River to the East Bay, the Los Angeles Aqueduct, which moves water from the Eastern Sierra, Owens Valley, and Mono Lake down to Los Angeles, Colorado River facilities that bring water in from out of California, and then the facilities at Hetch Hetchy Valley, which bring water to the city and county of San Francisco. So we move water around to address these special kinds of scarcity. Now, what I want to do for a good chunk of our time is I want to talk to you about the water rights, the legal rules that we use to allocate water between people and between people and the environment. And to start that discussion off, I want to talk a little bit about the relationships between the federal, state, and tribal governments. Now, most water law is state law. So in this talk, I'm only going to spend a moment on federal interests and tribal interests. The Supremacy Clause in the U.S. Constitution says that federal law is the supreme law of the land. However, our federal government is a government of limited powers, limited to those powers identified in the Constitution. The states reserve the rest under the 10th Amendment. Water law has a consistent thread of long-standing deference of the federal government to state law. What does that mean? It means the federal government tends to respect the state and defer to the state to give the state the power to allocate its own water. And there's a famous case in which the US Supreme Court held that states essentially can decide on the attributes of their own water rights systems. There are some important federal elements. Just one of those is that there's a certain kind of right called a federal reserved right for federal facilities and properties like national parks and national forests. The same kind of rights are held by some Native American tribes. These are reserved rights that guarantees to them the amount of water needed to fulfill the purpose of the reservation. There are also, particularly in California, some rights that are recognized that predate those treaties, these indigenous rights for uses that predated the treaties. That's an important topic and an interesting one. I'm happy to talk a little bit more about that after the talk. But the main point here is that most law around water in California is state law when it comes to defining water rights and how the water rights interact with each other. So we're going to talk now about California water rights law. And one of the most important principles in California water law is that the California Constitution actually contains a provision that forms our fundamental state water policy and controls everything else. And in the law, we have a hierarchy, and Constitution is at the top, statutes enacted by the legislature is next, and then laws enacted by the administrative agencies come after that. And the court cases are sort of hovering around in the middle of all of those, but the Constitution controls everything. And our Constitution, Article 10, Section 2 says, "It is hereby declared that because of the conditions prevailing in this state, the general welfare requires that the water resources of our state be put to beneficial use to the fullest extent of which they are capable, and that waste or unreasonable use be prevented." This is often referred to as the reasonable use principle. The reasonable use principle incorporates an underlying objective of maximizing social value. And we seek to maximize social value achieved from water by balancing multiple factors. We call it reasonable use balancing. And these factors can include environmental, economic, cultural, and many other factors that go into this assessment. One of the interesting things about the reasonable use principle is that if there's not enough water for two different uses, a use with a lower social value might be considered unreasonable simply because there isn't enough water for the two uses. California Supreme Court has confirmed that principle. We also say that the goal of maximum social value requires our decision makers to achieve maximum use by identifying what's called a physical solution, which in normal everyday terms means a common sense resolution to figure out how to maximize that social value without necessarily adhering to all the legal niceties. So that's an important concept. Another important concept that sort of forms an umbrella over all our water rights is National Audubon Society v. Superior Court. This court case articulated a longstanding principle called the public trust doctrine and integrated that doctrine, that principle, with our state water rights law. So the public trust doctrine originated in Roman law. It is a principle that says certain resources are held in common for the public. These include water resources, the beds and banks of water of lakes, rivers, and streams, and tidally influenced waters influenced by the ocean. And those resources were given to each state as it entered the union under what's called the equal footing doctrine. Every state joined the union and got, I like to tell my classes, a goodie bag. And in that goodie bag came the beds and banks of navigable waters and tidally influenced waters. But that title didn't come to the states free and clear. It came impressed with an obligation to protect our common resources, our common values in water resources. They originally protected the values of navigation, commerce, and fishing in waters. Today, they protect the environment, scenery, recreation, aesthetics, and scientific values in our waters. And the legal standard identified by the National Audubon Court, the California Supreme Court, was that our government has an obligation to protect the public trust resources where feasible, that water rights sometimes have to, water users have to engage in diversions that will adversely impact those trust resources, but we have to protect the resources if it's feasible to do so. Okay, so with those two overarching principles, I want to talk a little bit about our specific water rights system. To start off, let's talk about the nature of the property right in water. Water Code Section 102 establishes, this is a statute enacted by the legislature, says all water within the state is the property of the people of the state, but the right to the use of water may be acquired in the manner provided by law. So what do you have there? You have two kinds of property interests. You have the state, which protects the water on behalf of the people of the state as a whole, but you also have the state allocating private rights to water to individuals and individual water users. Often those individual water users, I should say, are local public agencies who supply water, such as cities and special districts. They supply water to customers. But the right to use of water can be held as a private right. It has a special name. It's called a usufructuary right. That's a really difficult, hard to spell, hard to say legal term. I'm sure I'm getting it wrong. The basic idea of the usufruct, as we say, is that it's a use right. So the usufruct inherently recognizes those two kinds of property interests. The state is the full owner of the right, but there is a user who also has a private, legally protected right. Under a usufruct, you have a right to use and the right to enjoy the fruits of that property. You might think of an orchard where the orchard owner owns the land, but somebody has a private right to grow the fruit on the trees, to harvest the fruit, and to profit from that fruit economically. That's a usufruct, right? So the private property right, the usufruct, is entitled to legal protection, but it's also subject to the power of the full owner. And when we say full owner, the state's interest is not proprietary in the ordinary sense, but regulatory. It means the state can enact laws to protect the public interest, even though someone holds this private usufructuary right. So that's the nature of the property right in water. Now let's talk about some specific kinds of water rights. When you want to understand water rights, you have to ask two questions. The first is, physically, what kind of water is it? Is it water that's found on the top of the ground, surface water, or is it found under the ground, groundwater? The second question you have to ask is, how is the legal category originated? Are you claiming the right to water because you own land that is physically next to a water course? That's a land-based right in water. Or are you claiming a right to water because you're putting that water to beneficial use? That's a use-based right to water. So let's look at these water right categories in the context of surface water. So water law is a fascinating mix of history and politics and economics and science. And yes, there's a little bit of law in there too, but it is all of these things. And there's so many wonderful stories, some tragic, all interesting, all challenging to deal with today. So we have to talk a little bit about history to understand water. So we'll start at the gold rush. As all good storytellers do, we start with once upon a time. Once upon a time in California in January 1848, gold was discovered not too far from Sacramento, and people came west to seek their fortunes in gold country, either to find gold or to sell things to people who were finding gold. In 1850, California entered the Union. It joined the United States, got its goodie bag of resources, which were impressed with the public trust. And along with that, California decided it needed some reference, some form of law. It said, we don't have laws yet. We haven't enacted any. So where are we going to look for our laws? And they said, how about England? Everybody looks to England. So they adopted the case law of England, the principles in the case law of England as our law, the English common law, as we say. Well, under English law, they had a special kind of water right called a riparian right. So a riparian right is a right based in land ownership. It's a perpetual right to an amount reasonably needed on land that is adjacent to a surface watercourse, adjacent meaning next to or contiguous. So in the picture here, you have a river. Parcel A, the legal parcel A, probably has riparian rights. Parcel B probably does not, because it is legally separated from the river. I say probably because I'm at heart a lawyer and there are always exceptions, but that's the general rule of a riparian right. So of course, water rights only matter in a shortage. So the key question you want to ask is, well, what happens when there's not enough water to go around? What's another name for a shortage? It's a drought, right? So what happens in a drought with riparian rights? We say that riparian rights are allocated based on a correlative principle. A correlative allocation is one that is legally equal. There's no specific quantity associated with it. It's whatever is reasonable, but the water has to be used on the riparian land in the riparian watershed. Now, because the right is grounded in ownership of land and not grounded on putting the water to beneficial use, it doesn't matter when riparians start using the water. So in this picture here, we have at the upstream side, we have a riparian user who's acquired their interest in land in 1870. And let's say they started using water that same year. Then we have downstream a land-based right that started using water in 2020. Now, it doesn't matter when they acquired their respective rights in land. If one was 1870, one was 1900, it doesn't matter because they're correlative, they're legally equal. It also doesn't matter when they started using water, 1870 or 2020. These two users as riparians are legally equal. The water is allocated between them on a reasonable basis, which is essentially, as I said, a balancing of multiple factors. It's an equitable balancing. It takes into account what's fair, looking at things like economic, social value, the degree of harm caused, and all kinds of other factors. So we had riparian rights because California integrated English common law when it became a state. But something else was happening at the same time. And what happened is when we had those gold miners come to California in 1848, and then later agricultural interests who wanted to grow crops in the wonderful soils of California, those folks could not claim riparian rights. And they couldn't claim riparian rights because riparian rights are land-based. And at the time, most land was held by the federal government. There was very little, there was some private land ownership, but very little relative to the amount of public land, and certainly where they wanted to do the mining and the farming. The other problem is that riparian rights, because they were based on this squishy reasonableness with no fixed quantity of water, they were very uncertain. Also, it had to be used on the riparian land. And here's another really important limitation on riparian rights. They only attach to what we call natural flow in the river, which means, as a practical matter, you cannot store the water in wet seasons or wet years for release in dry seasons or dry years. That's not natural flow. You can only take what naturally goes by in a state of nature. And no storage, of course, as we saw with John Wesley Powell, is a major issue. So riparian rights didn't work for these miners and farmers. So early on in 1855, the California Supreme Court recognized another kind of water right in this famous case of Irwin v. Phillips between two miners. And that water right was called an appropriative water right based on the doctrine of prior appropriation. Now, prior appropriation is not about owning land. It's about who puts the water to beneficial use and creates social value from the water. Instead of being allocated in a shortage based on correlative principles, it is allocated based on priority. The phrase is first in time, first in right. Whoever put the water to beneficial use first gets the water. My legal scholars are twitching a bit because the rule's a little more nuanced than that, but I'm going to leave it there. We say that the person with the earliest priority is the senior, and the person with the later priority is the junior. So if we had somebody who put water to beneficial use in 1911, they're the senior user. If they're a junior user, they put water to use in 1950. The idea is that the senior gets all the water they need before the junior gets any. Because it's based on beneficial use, the appropriative right is governed by a principle of use it or lose it. If you're not turning it into social value, you can't have it anymore. It had some benefits over riparian rights. You can use it off the lands. You don't have to use it on the land next to the river. You can use it wherever, right? You can take it out of the watershed. You can store it in reservoirs. And a lot of our rules and principles that develop around appropriative rights were designed to encourage and protect the investment of those who invested their money and resources in diverting the water and applying it to beneficial use and providing it for drinking water or growing crops or however they generated the social value. The state, through its laws, wanted to protect that generation of social value. So that's where a lot of our principles came from. Now, one of the interesting things was California decided in the mid-19th century, late 19th century, not to eliminate riparian rights, even though we developed this new system of appropriative rights. They said, let's keep them both. I think that was probably not a good idea as things worked out, but there were reasons for it at the time. So we had both appropriative rights and riparian rights going into the 20th century. And in the early part of the 20th century, the state of California realized that if it wanted to actually use water at a large scale to support our cities, to generate hydropower, and to do big things with it, we actually needed a better system than we had at the time. At the time, we were relying on just case law to allocate water. We didn't have any real central state government agency who was in charge of all this stuff. So a group of people got together at the direction of the governor in the early part of the 20th century, the Conservation Commission, and they recommended that we create a statute which would create a water right permitting system. And that was ultimately became the Water Commission Act of 1913. That created the predecessor agency to what is today the State Water Resources Control Board, which has the authority over issuing water right permits today. Now, one of the interesting things about the Water Commission Act was that it created for the first time the obligation for somebody to file an application for water to get a permit, which would then later become a license in order to use water. However, it did not eliminate prior existing appropriative rights. We call these pre-1914 rights. Why 1914? Because the Water Commission Act of 1913 had an effective date for this water right system of December 1914. So you will hear rights that post-date the act that are acquired through application and permit as a post-1914 right, and those that predate as pre-1914 rights. These are still valid, these pre-1914 rights, these case law rights recognized under the common law, another word for case law. Also, the riparian rights are still valid. So these existing common law rights were valid. They did not need a permit. They did not need to go to the state board and get a permit. The state board does not have permitting authority over them. The state board only has authority over new appropriations after 1914. So that's the system we live with today, today's State Water Board. The permitting system applies to post-1914 rights. So how does this all work in a shortage? How do we put all these things together when we have drought? Well, that is where we come back to this idea of priority. The idea of priority is to allocate water in a shortage. Priority defines the property right in water. It says how much you get when there's not enough to go around. So if your priority date is a particular date and there's not enough water for you and you use water, you're actually not within the scope of your property right. It's like, I'm in my house, I have a deed to my house, but if I go over to my neighbor's house, I don't have a right to their house, right? Your property right is defined by priority. So let's look at this example here. If you have a river that flows from the top of the screen to the bottom, you have somebody at the upstream level who has a state board permit with a priority date of 1950. You have a common law pre-1914 appropriative right downstream of 1911, and then you have a riparian right downstream of that. In our mixed system, riparians are generally, there's an exception, but generally senior to appropriative rights. So the 1950 right and the 1911 have to let water go by until the riparian gets all the water they need. This is the theoretical way in which it works. Then 1911, so 1950 has to let water go by until 1911 gets all the water they need. And then and only then can 1950 take water. That's how the water rights work together. So priority is supposed to allocate water in a shortage. So let's talk about how that works today with the State Water Resources Control Board. The State Water Board of today has authority not only over the water rights system, but also over certain extensive water quality issues. So they combine the water rights and water quality functions in one board. They're under the umbrella of the California Environmental Protection Agency. It's a 5-member board appointed to staggered terms by the governor, full-time members with 4-year terms. They represent a range of experience: civil engineers, professional engineers, water quality members, attorney member, and a public member. And they work with a staff on water rights issues called the Division of Water Rights. So the role of the state board has evolved over time, and particularly in connection with this Article 10, Section 2, our fundamental constitutional state water policy of reasonable use. The function of the board has been recognized through statutes enacted by the legislature and through case law to increase over time from its narrow role of issuing permits and licenses for post-14 water right holders, which it still does, to comprehensive planning and allocation of waters. The problem is that the state board's powers today being so different from what they were in the beginning, there has not been a clear, clean delineation of authority over certain kinds of water rights, and that includes those pre-14 and riparian rights in particular. The state board does not have permitting authority of those rights, but it is said that under Article 10, Section 2 and the public trust doctrine, the board has regulatory authority of those rights. They can call those people in and have them adjust their water use in order to protect against waste or unreasonable use, or to protect our public trust resources. There are some statutes enacted by the legislature which also give the board some regulatory authority over those water rights. So what happens in a drought when the board's at the helm of the water rights system and you have all these different water rights functioning in California? Well, until recently, the board hasn't been deeply centrally involved in managing during droughts. And it was only with the drought of 2014-2015 that the board really started taking on a major role. It had taken some actions when we had a major drought in the mid-1970s, but really it was 2014-2015 where you started to see the board exercising its broad authorities. Today, in the drought of 2021 and 2022, the board has some resources available to it. One resource in particular is a water code provision, which authorizes the board to adopt what's called an emergency regulation. And there are some conditions on the board's use of this emergency regulation. The regulation is like a statute enacted by the legislature, but it's enacted by an agency. And this regulation has to be necessary to prevent waste or unreasonable use within the meaning of the Constitution. And you need to have one of two conditions. Either the governor has to proclaim a drought emergency, or it has to be the 3rd year of drought. If those conditions exist, the board can adopt regulations that then, under a streamlined process that's different from its regular regulations, that then impose some requirements on all of these water users post 1914, pre 1914, and riparian during drought. That emergency regulation is temporary in nature. It only lasts for a short period of time. The board either has to, it either goes away on its own, or the board has to adopt permanent regulations. Once the board adopts an emergency regulation, it can adopt what's called a curtailment order. Now, curtailment is a fancy word. We haven't heard it much in California before, but the other Western states use it all the time. And it simply means water users halting diversions in order of priority. So the junior users have to stop diverting so that the senior users can take water. As we said, that's what defines their property right in water. The State Water Board does watershed level water supply and demand calculations to figure out how much water is available for diversion and how much demand there is, so they know where to draw the cutoff line. People up to, if water availability shows up to 1913 can divert, but not 1914 or later, whatever the data happens to show. One of the things the board can do through the emergency regulation is not only enforce priority, but it can also adopt some policy in those regulations. The two main policies the board has adopted are to adopt some minimum flows for fish in some water systems that it then subtracts from the water supply, the water availability calculation, before it figures out who can divert what, and some exceptions to priority for health and safety. Now, you see in the news references to the board terminating water rights through curtailments. And this is something I want to clarify. If you come away from this talk with one lesson learned, it is this: curtailment, if it is merely enforcing existing priority, does not terminate a water right. It is entirely consistent with a water right. It's like telling somebody you can't go sleep in your neighbor's house. We already know you can't go sleep in your neighbor's house, right? It is simply enforcing priority. The difference is that in the past, there was no central government figure saying you have to enforce priority. Instead, the water users figured it out for themselves. And to their credit, they did it quite well on some systems. They are very sophisticated. These are people who manage water, and frankly, some of them are downright heroes at what they do. They do a great job. But in some systems, they don't do such a good job. And the local water users aren't as good at looking at statewide interests as they might need to be, including protection of fish and protection of disadvantaged communities and protection of indigenous rights and other issues that you really need a statewide perspective. So that is one of the reasons we have, in these times of extreme drought, the State Water Board stepping in. If water users fail to comply with curtailment orders, the board will bring enforcement actions. And there has been, in response to some of these enforcement actions, some litigation challenges based on claims that the board didn't afford appropriate procedures, what we call due process in the law, before it adopted these orders. And people challenged the board and said, you don't have the authority to adopt these orders with respect to these pre-1914 and riparian rights, which aren't under your permitting system under the water code. And so those issues went to court. There have been three essentially, one superior court, two appellate court opinions that have come out in recent years on the most recent curtailments. In one of those cases, the Stanford Vina case, the State Water Board won at the appellate level. The courts upheld the board's use of the emergency regulations and its policy decisions to adopt minimum flows for fish, and said that the board had done everything it needed to do in terms of process in that case. In the other litigation, the water right holders won on appeal. Now, in this case, this was just decided within the last month, September 2022, a month and a half ago. The water right holders won because in that case, in those curtailments, the board had invoked the authority of a specific code section, not the emergency regulations we've been talking about, but a different code section in order to enforce the curtailment orders. And the board doesn't, in the current curtailments, rely on this section. But that particular section had some language in it that suggested to the court that the board shouldn't use that section in order to assert authority over a group of pre-1914 and riparian right holders in order to enforce priority in a drought, in order to adopt curtailment orders. It said the language of the statute suggests to me, the court, that's not what the legislature intended. In so holding, the court acknowledged that its reasoning was limited to that code section. And if the board had relied on different legal authority, like the emergency regulations, like Article 10, Section 2, or the public trust doctrine, that there probably would have been a different result in the case. So given that the board does not now rely on that code section, it's a relatively narrow holding, we say. It has relatively limited impact. It is challenging because the board doesn't have the best tools it should have to be taking away some tools from the board when it needs everything it can to bring this statewide perspective to drought. And in California, we really do experience these perpetual cycles of drought, and we need to plan ahead. So my recommendation is that the State Water Board should have broad authority to to enforce priorities and adopt policies to protect water resources during drought. And I've been part of some research teams that have looked at these practices in other states where they engage in this kind of curtailment action, meaning managing priority all the time, not just in drought, but all the time, because it's how the water rights system is supposed to work. Now, to be fair, the water users have some arguments related to the board's data, to the assumptions it's making as it's calculating supply and demand. And the water users and the board are working together to iron out these challenges and to figure out how to navigate them better. And the water users are in many cases stepping up and acting as a partner to the board. And I'm optimistic we can keep going in that direction, although I wouldn't be surprised if there wasn't more litigation ahead. There are some targeted legal changes that I and others have recommended to clarify the board's authority to take these actions during drought. Happy to talk about those down the road. Now we have a little bit of time left, so I wanted to talk a little bit about the topic of groundwater. We've been talking about surface water. Groundwater actually operates along analogous, but also different rules. And so I wanted to address it separately. Let's talk about why groundwater operates according to different rules. And it's because the Water Commission Act of 1913 said that the permitting system does not extend to percolating groundwater. So the board has never had permitting authority over percolating groundwater. And while Article 10, Section 2 gives the board authority over all water rights in California, that constitutional reasonable use provision, the board has not historically exercised regulatory authority over percolating groundwater. Groundwater has been viewed differently by people who pump groundwater. I think because they're pumping it out of the ground, and in many cases, they're using it to grow crops on their ground. There's something very special, very primal and spiritual about their connection to this groundwater. So they guard it fiercely. And the board has not traditionally engaged. What happens to let's talk about what kind of groundwater rights are there and what happens to them in a drought. So in terms of the basic categories of groundwater rights, they're analogous to the surface water right categories. There's a land-based right and a use-based right. The land-based right attaches where you have land that overlies a groundwater aquifer. An aquifer is just a formation underground that holds water, right? That you can, out of which you can pump water. And if the water overlies, sits on top of the aquifer, it has a land-based right, and it can drill a well and it can pump the groundwater, and it doesn't need a permit from anybody. And that's a land-based right. So it's like a riparian right. It's correlative, doesn't need a permit. You don't lose it for non-use, right? All of those things that applied to riparian rights apply to overlying rights. Now, if there's enough water in the groundwater basin, you can also have a different kind of right called an appropriative right. So an appropriative right exists in some situations where the water is pumped and then used outside of the basin. Now, why is that? Well, remember, riparian rights have to be used on the riparian land in the riparian watershed. Same rule for overlying rights. So if they use it off the overlying land outside of the basin, it then changes as a matter of law, transforms magically into a new kind of right, which is based on use of surplus water. The surplus water is called an appropriative right, same word we use in our surface water system. This appropriative right also exists where you have a public water supplier who is, even if the public water, so let's say it's a city, and the city is sitting on top of the groundwater basin. If the city drills wells and pumps groundwater, but then serves it to customers, the city is not acting as a landowner. The city is pumping that water and serving it to people who own the land on which they live, right? So the city's not acting as a landowner. It doesn't hold an overlying right to that water. Instead, it's magically transformed into this use-based right and appropriative right. Well, as with surface water, the land-based rights are senior, the use-based rights are junior. So the overlying users are senior to the appropriative users, including the cities. So what typically happens to those water rights when there's a shortage, right? When there's a shortage? Well, historically, the courts had to get involved. In many instances in water law, the courts have authority coexisting with the state board's authority. We say it's concurrent jurisdiction. In this case, for many years, the courts exercised the primary authority over groundwater. And you would go to court and you would say, there's not enough water to go around. And you'd ask the court to figure out who gets how much water and when they can pump it. And that's called a court adjudication. Now, a court adjudication usually comes up when there's not enough water to go around. And in the groundwater context, we call that overdraft. Now, the idea of overdraft is not a drop in groundwater levels just over a 1-year period or even a 2-year period during a dry period. Overdraft is the concept of a long-term decline in groundwater levels, where even when it's raining, the groundwater levels aren't coming back up to where they started originally. You can see in the little chart here how the line, even though it goes up and down, up and down, up and down, the trend over time is downward toward the bottom of your screen. That's overdraft. That's when the water levels are declining over time. In that situation, the court can set pumping levels to achieve what's called safe yield, meaning we're, for our purposes, correcting overdraft and avoiding what is called very officially undesirable results, which means things like we're not causing land subsidence where there's so little groundwater, the land sinks. We're not affecting water quality, right? We're not losing long-term groundwater storage. All of those things, we're trying to avoid that through this adjudication to set a level of pumping that will protect the water levels. Now, one interesting legal thing happens in overdraft. The overlying rights and appropriative rights change somewhat. And in particular, remember the appropriators are junior to the overliers in a classic groundwater basin scenario. When there's overdraft, the courts have held that active groundwater pumpers can acquire a special kind of right called a prescriptive right, where they then become legally equal to the overlying users who are also actively pumping, engaging in what's called self-help. If whoever's pumping has their rights protected. So it changes how the water rights work. And the court will set that safe yield and allocate some amount to the overliers and to the prescriptors in this adjudication. So that's how groundwater adjudication worked for decades. For a long, long time in California, that's how groundwater is allocated in a shortage. 8 years ago, in 2014, we reached a point at the threshold of the drought of 2014, 2015, where it became apparent that we couldn't rely on groundwater adjudication to address our groundwater problems, that not enough areas were adjudicated. Southern California has a lot of adjudicated groundwater basins, and there's a few in Central California as well. But for the most part, some of our most impacted basins are not adjudicated, and adjudications are expensive. They take years and years and years. Some have taken decades. They're complex. They're not always the best solution. So with the drought creating the political impetus to address groundwater, we adopted a new law. The California legislature adopted a new law called the Sustainable Groundwater Management Act. Now, the Sustainable Groundwater Management Act does a lot of interesting things, but it still does not create a permitting system for pumping groundwater. You never need a permit to pump this groundwater called, why do I keep calling it percolating groundwater? It's because there's this small category of another kind of groundwater for which you might need a permit, but it's relatively minimal, so I'm ignoring it tonight. But for most groundwater in the state, you never need a permit from the state. No permit. If you're an overlying user, you drill a well. If you're an appropriator, you drill a well. You might have to go to court, but still no permit, right? The Sustainable Groundwater Management Act, or SGMA, creates a framework to attempt to achieve safe yield to protect those groundwater basins without going to court. And the framework is essentially that we created new local agencies called groundwater sustainability agencies, which are made up of existing local agencies, GSAs. We love our acronyms in groundwater. Sustainable Groundwater Management Act is SGMA. Groundwater sustainability agencies are GSAs. They have to prepare plans, groundwater sustainability plans, or GSPs, to identify the safe yield, or what's called sustainable yield, of their basin. And they have to attempt to achieve that sustainable yield by 2040 or 2042, depending on the status of their basin. The fundamental philosophy of SGMA is that groundwater is best managed locally, that the locals know the groundwater basins best. They have the most invested in making the system work. But that if the locals don't carry out, if these GSAs don't comply with the law and don't achieve sustainable yield or a number of milestones along the way, the state can step in. And so the State Water Board has a role under SGMA. It can step in if a basin is failing to meet its requirements. Interestingly, we have another water agency called the Department of Water Resources, which manages our state water project, and it was given the authority to review and confirm that groundwater sustainability plans have complied with the requirements of the law. So you have DWR reviewing the plans, and then you have the plans being implemented. If the plans don't achieve their goals, the State Water Board can step in. That's SGMA in a nutshell. And that is our approach to managing groundwater in drought. It's hard to talk about groundwater in drought at an aggregate level because the solutions are so very different on a local basis. And there are many local basins who are doing some really interesting things to achieve sustainability and to protect their groundwater basins, including groundwater banking and recharge programs, all kinds of interesting recycled water programs, all kinds of programs. And some of them do it quite well. So you really have to talk about the individual basins to have a useful conversation. So one thing I wanted to note here, and I'm happy to talk more about it in the chat or during our Q&A, which is about to start. We do have in California some threads in the law that recognize the importance of drinking water. And one of those threads in the law was a law enacted in 2012, the Human Right to Water Law. And the Human Right to Water Law doesn't change groundwater rights law, not directly, but it has had a significant influence on how the laws are implemented. And I think it will continue to have a significant influence, and I hope it does. We have a long way to go when it comes to ensuring that our most vulnerable communities have clean and reliable water supplies. We've done a lot so far, and I hope we can continue to do a lot more as we go forward. And I'm happy to talk about what the Human Right to Water Law says and what it does as we get into our Q&A. But with that, I will close. Thank you for your time. And I will turn it back over to our moderators, and I welcome any questions.
Thank you, Professor Harder. That was a really great and engaging and informative talk. And so now we are going to open up to any questions. And if you have any, please feel free to type them into the Q&A window. Mona, did we get any questions during Professor Harder's talk?
Oh, yeah, we have a lot of questions, Michael.
Perfect.
And we have 10 open questions at the moment. So keep submitting your questions and we'll get to as many as we can. Okay, first question. How are water protections adjudicated for areas of origin in California? The protections for areas of origin have been nebulous and not clearly adjudicated in the past.
Great question. So let me clarify this term area of origin. So I talked about those projects that we built to move water around the state, the Central Valley Project and the State Water Project. When the projects were built, their purpose, of course, was to move water from those areas where it snows a lot and it rains a lot to the areas, those dry areas where the people are. In those areas where it snows a lot and rains a lot, there were people living at the time. And some of those people were unhappy at the idea of the water being moved away from their communities through these projects to new communities. And while most of these areas are very rural, they said, we might want the water someday. And so the political compromise was for the legislature to adopt these area of origin laws, which give certain protections to these areas. Now, you have to, there's a couple different kinds, several different kinds of area of origin laws. I'm going to focus on two of them. One is called the county of origin law, and one is called the watershed the watershed of origin law. So the county of origin law basically operates like this. It's got a very specific legal framework in which it operates. The state of California filed mass water right applications in order to appropriate water for the state water project and other state purposes. In those, they're called the state filed applications. In those state filed applications, there is a place of use identified. Water rights, appropriated water rights are defined in part not only by priority, but by what we call their place of use, purpose of use, and point of diversion. So the place of use in these water right applications is identified as some of these counties of origin, these places where the water originates, are high mountain counties where the headwaters are. And the law, the county of origin law says when those counties are ready to use the water, they can file an application for assignment of the state filed application if they can prove that the water is necessary for the development of this county of origin. So the tricky thing about the county of origin law is that you do have to file a water right application, and then you have to be ready to use the water. And that typically requires storage, which means you need a reservoir, which means you need a lot of money. You need a plate, you need the resources to store, convey, divert, store, convey, and treat this water. And so these rural areas have not developed at a pace that would allow them to raise the money sufficient to apply for that water. The watershed of origin law works a little differently. It says that if some of these areas that qualify as watershed of origins, and those can go pretty far out, the Stockton area, San Joaquin, parts of San Joaquin County qualify as a protected watershed area. They can file what's called a request for release of priority Basically, what this means is that the federal Central Valley Project and the state water project can't say to whoever filed the request for release that the federal project and the state project are senior. They have to say, okay, even though you're filing later in time, we won't assert our first in time priority as against you. So it's just a release of priority by the projects. Again, that doesn't help much unless the person who's requesting release of priority has access to resources that help them store, divert, treat, convey, etc., all this water. So this is why you haven't seen a lot of development of the area of origin protections.
Great, thank you so much. Okay, let's go on to the next question. Okay, is it true that streams have specific beneficial use designations and that those were put in place decades ago? Plus, are these rules on many fish-bearing streams, biological resources not designated as one of the beneficial uses?
So we use the term beneficial uses in a couple different contexts, a couple of different ways. When I talk about beneficial use as a water allocation expert, I'm typically talking about categories of use that reflect social value: drinking water, other residential uses, municipal and industrial uses, water for agriculture, hydropower, frost protection, recreation, and fish and wildlife purposes. Those are all beneficial uses. But when you talk about designated beneficial uses, that's a term of art. It's a phrase used under our water quality laws. And when we talk about protecting water quality in these streams, the law is structured so that you adopt water quality standards to protect a certain designated beneficial use for that system. And those designated beneficial uses were in some cases made a long time ago, but they can change over time whenever there's a new water quality decision by the relevant state agency. In some cases, the State Water Board, in some cases, the Regional Water Quality Control Board. So we're using them in a couple different senses. Those plans are amended occasionally. And in fact, the Water Quality Control Plan for the Bay Delta is currently halfway through an update. It's been many years. It's been going through an update, and it is partway through.
Great, thank you so much. Okay, next question. Which factors contribute to California being less aggressive than other Western states in curtailment actions?
Good question. Couple of things. In some Western states, they didn't make the mistake, I would say, of holding on to riparian rights. So their systems are a lot less complicated. They only have appropriative rights. And in some of those states, they only have a single system. They don't divide them up into common law and post-statutory rights. In some of those states, they don't recognize protection of in-stream resources, fish and wildlife, and water quality as key goals of water allocation. So that makes their systems even simpler. And in some of those states, even where they recognize all the things, they're just smaller states with fewer people. And California is the 5th largest economy in the world. And we have some of the most extensive developed uses of water, including agriculture and hydropower, in the Western states. And so that's a lot of people and a lot of interests to bring together under one umbrella. So it's just more complicated in California. I think we can get there, though. I think we can. I think many water users do see that having a functioning system with somebody who's an umpire calling the shots while they all play the game, I think they see that's going to be beneficial to them. They don't want somebody taking their water, and they want to know how much should they leave in stream for fish. And so the more clarity and certainty we can provide around those things, actually, the better their systems are going to function. I think we'll get there.
Oh, I hope so. Thank you. Okay, so the next question. Is it true that in the Water Commission Act of 1913, it was waived the obligation to obtain a water permit for groundwater because there were very few groundwater users?
I haven't heard that. My understanding is that the official explanation was that groundwater resources were too complex to understand because they were secret and occult. They were hidden under the ground. I think that the researchers have showed that really groundwater users, to the extent they existed, were very protective of their groundwater rights. It was a political, you can't come after my rights sort of thing. But certainly the question is correct to the extent that the technology for pumping large quantities of groundwater and using that to support large amounts of agriculture had not fully evolved when the Water Commission Act of 1913 was adopted. So you certainly did not have groundwater use to the extent that you do now. That is absolutely true.
I just want to jump in real quick and make a quick comment for anyone that's asking about specific regulations or statutes. If Professor Harder can't answer it directly, you're more than welcome to reach out to the law library, and we can provide copies of these older superseded statutes, so that way you can kind of determine what they, how they read, how the text looked at the time. I just want to quickly jump in and insert that. Sorry for interrupting.
That's a wonderful, wonderful resource you have available there. And I'll also suggest anybody interested in that issue should read a study that was prepared by the late Professor Joe Sachs for the State Water Resources Control Board. It's available on the State Water Board's website. It's called We Don't Do Groundwater, a morsel of groundwater history. And then there's a law review article and then a report that he prepared specifically for the state board. And he talks about why groundwater was excluded from the Water Commission Act. And then you can go look at it for yourself and read all those wonderful, the legislative history through the Witkin State Law Library. I'm going to be doing that. It's a great resource.
Thank you for that. Okay, next question. Can the state start making building salinization plants a priority?
Good question, desal. So the state, I believe, needs to bring all possible resources to bear to develop new sources of supply. And in fact, the governor's water plan, the most recent water plan adopted in the last couple of months, identifies new sources of water as a priority. Desal is not an area that I know really well, but what I do know is that it is very complicated, in part because in the past it has been prohibitively expensive. Those costs are changing, particularly as water becomes more valuable, but also because the desal projects that are proposed can have impacts on other water resources and on the environment. And so, of course, we care about all of those potential impacts, and working through those has turned out to be very complex for the desal plants that have been proposed for some of them. There are, I believe, there is at least a couple working desal plants, but others are still going through the regulatory process. I hope we figure out a way to do all of those things.
Okay, great. Thank you. Can you briefly go over the water supply issue in Coalinga?
Oh, I'm sorry. I'm not familiar with the water supply issue in Coalinga. I actually had somebody ask me about that, a reporter recently, but I haven't looked into it. And one of my basic rules is I don't weigh in on things where I don't know the facts. So I'm afraid I'm going to have to take a pass on that question.
Okay, no problem. Do you have any comments or opinions why they aren't building new reservoirs sooner than later?
Why they are or
Why
aren't?
they aren't? the
Why
question
they
asked
aren't.
why
Oh,
they are not. Yeah.
absolutely. Yeah. Reservoirs are very controversial because the reservoirs have numerous benefits. They provide flood control for numerous peoples in the state of California. They provide this water supply for drinking water, for agriculture. They produce hydropower. They provide recreation, and they provide water for fish and wildlife and water quality below the reservoirs. But reservoirs also have had massive impacts on the systems on which they sit. They have created out of natural rivers, they have created straight channels. They have increased temperature. They have changed the volume and timing of flows, which has significantly affected fish populations, salmon, steelhead, riparian vegetation. They have decreased dissolved oxygen in the rivers, which is necessary to support these fish species. They've had all kinds of impacts on recreation, whitewater rafting and downstream fishing, which has had in turn economic impacts. So reservoirs have both benefits and they have significant costs. And in the California of today, where we are very aware of environmental costs, we have to look at the whole picture to decide whether something is worth it. And I neglected to mention, and I should not neglect to mention, that reservoirs, by affecting the flows and fish populations, has also had significant effects on downstream tribal communities. So we're very careful about approving those kinds of impacts. And today, there may be some room for increased surface storage in the future. There are some proposals out there that are going through, that receive some state grant funding, that are going through analysis, which may in the end be good proposals. I don't offer an opinion one way or the other on those, but really I think the future of storage in California, and storage is very important, as we heard, the future of storage in California is in groundwater. And we have groundwater basins that are below where they need to be, lots of room to make sure those water levels come up, and to put new water in there. We can recycle water, and then we can spread it to percolate back into the groundwater basin, or we can not pump and use recycled water. There's different ways we can capture storm water. We can do all these things where we're managing our surface water and groundwater together, and we need to effectively use those groundwater basins. This is the great hope of the future. And in fact, there's been a lot of attention in the Sigma process and the GSP process on ways in which we can improve groundwater recharge and maximize our use of groundwater storage. And the State Water Board has adopted regulations to help streamline part of that process. There's more work to do on the law on that, but that storage, that's really where I think we're going to find the most benefit down the road, groundwater recharge.
Okay, great. Thank you. We still have so many questions left, and we are getting short on time, so I'll read a few more. So how should drought conditions weigh into water quality related policy and enforcement under the Porter Cologne and Clean Water Act? That might be a big one for a short period of time, but
that's a big one for a short period of time. I'll just say this: when you look at the water quality standards under Porter Cologne, and you set the requirements for water quality standards, you have to take into account the natural variability of the system as it exists in the past, today, and as it will exist in the future under climate change. And you have to take into account sort of our baseline conditions when we think about what beneficial uses we want to support in those systems. So yes, I think that the short answer is that we do have to take into account what drought has done, is doing, and will do to those systems when we structure the water quality requirements under those laws.
okay, great. Thank you for summing up. Okay. Why is the implementation time for the SGMA and the CV salts so long? I'm thinking this might be one of your students. Question from a student.
So the Sustainable Groundwater Management Act, or SGMA, has a timeline that requires sustainable yield to be achieved by 2040 or 2042. And the groundwater sustainability plans were submitted in 2020 or 2022, depending on the status of the basin. So they have essentially a 20-year timeline to achieve sustainable yield. And the reason for that is because we can achieve sustainable yield only in a couple of ways. We can control demand by reducing the uses for which we use groundwater. We can reduce pumping, and we can introduce supplemental water. The culture, communities, and economies that have built up to depend on the pumping in these basins are significant. And if you were to change just in a very short period of time the amount of pumping you could do from one of these basins, you would devastate these communities. People would be out of homes, people would be out of jobs. It would not be sustainable. Businesses would go bankrupt. You need a period of time in which to transition communities and businesses so that they can weather the change. Change happens gradually. If you're building a water supply project, building any kind of project, even if it's good for the environment, like a recycled water project, we have a lot of environmental laws you have to comply with and a lot of processes that you have to work through. And those take years and years, and they take lots and lots of money. So you have to raise the money, often being paid for through ratepayer money, through public monies, or pumping charges on people who pump groundwater, depending on the situation. And obviously we can't fund all those things all at once. You don't want your water bill going up to, $10,000 or whatever. You need it to be at a reasonable amount. So you have to do this over time, build the water projects over time. And that's why it has such a long window. Certainly there are some situations in which the situation is so dire that actions need to be taken sooner. There are some groundwater basins where the groundwater is declining so rapidly that there have been proposals to not drill any new wells, for example, for a period of time. There are some groundwater basins where they're so impacted by water quality that those who have domestic wells, those rural properties that have wells just on their property, they don't rely on a water supplier, and they're pumping from their wells, and either their wells are dry or their groundwater is polluted. That is a terrible situation that has to be rectified immediately. So there are some things that need to be addressed immediately that are being addressed immediately, hopefully, and we've got a lot of good organizations out there trying to make sure they are addressed immediately. But it is a process, and I think there's more to do in that regard to protect these very vulnerable uses. So some stuff immediately, but a lot of it does have to take place over this long period of time to be feasible.
Wow, so many issues. Okay, great. So we're getting close to the end of our time. There's a couple more questions. Let's see. You were getting, Professor Harder, so many comments from so many people that have enjoyed this program. So thank you so much for your time. And we really appreciate it. But I'm curious about this question, just to circle back to desalinization just for one more second. This question asks, do desalinization plants have the right to the fresh water they make, the right to distribution, or will other water right holders be able to make a claim to it?
So we have some principles in California water law about supplies of water where somebody has invested in those supplies of water and made them available where they otherwise would not be. It's called the developed water principle. And in many instances, this isn't settled, but in many instances, it seems likely that the desal plants will have a claim to those supplies based on this concept of developed water, but it may depend on the specific circumstances of the desal plant, where it's getting its water from, and what agreements it had to make in order to operate. So very fact specific, but in some cases, this developed water principle means that the person who invested gets the water.
Okay, great. Thank you for answering that. Okay, here's a short one. Can water rights be nullified?
Nullified as in taken away? That's a great question. So yes, there are a number of circumstances in water rights can be taken away. Number one, if the water is wasted or unreasonably used, the courts have said there is no property right in water any longer, right? So water rights have been acknowledged to be essentially gone if they are wasted or unreasonably used. If you have an appropriative right, a right that's based on beneficial use, and you fail to put it to beneficial use over a consecutive 5-year period, you can be said to have forfeited the right. And we saw in the groundwater context that under certain circumstances, in the context of overdraft, active pumpers can prescript water, which then effectively could, in a sense, take water from someone who might otherwise have claimed it. Now, you don't have prescriptive rights to surface water that otherwise should be part of the State Water Board's permitting system. I call it the appropriable pool, the pool of water subject to appropriation. There's a case holding that you can't just claim that water just because you put it to use. You have to file a water right application. But in the groundwater context, you can claim water that you put to use, and that may be taking water away from somebody else. I would say those are the main ways. For a riparian right, you can lose the right to use water if you subdivide the property and a portion of the property is no longer adjacent to the stream. In some circumstances, you can lose the riparian right. And if you lose the riparian right in that context, you can never get it back.
Okay, great. Thank you so much, Professor Harder. There's still a couple more questions, but I know we're at the end of our time. So I'm going to turn it back over to Michael, and he'll let folks know how they can get in touch with Witkin or perhaps with you too. And thank you.
Thank you. It's been my pleasure. And I do invite people to reach out to me to learn more about water law or to learn about the resources that we have at McGeorge School of Law for learning more about water law, including water rights, water law degrees for non-lawyers. We have a Master of Science in Law program where those who don't want to be lawyers but really want to know more about the law, policy, and regulatory framework for water law can earn a degree. We even offer that in an online part-time format. So just feel free to reach out to me at McGeorge School of Law.
Wonderful. Thank you so much to Professor Harder. This brings us to the end of the webinar. And so Mona, if you wouldn't mind just putting those 3 links back in the chat window. And for everyone else, please don't forget to sign up for our quarterly e-newsletter so that you can get updates from the law library. And if you're in the area, please feel free to visit us in person at 914 Capitol Mall in Sacramento, Monday through Friday. And if you can't visit us in person, please feel free to reach out to us via the State Library's website. And then lastly, if you have just a few extra minutes, a survey is going to open in your browser when the webinar ends, and it'll also be mailed out to all attendees tomorrow. If you can take a few minutes to fill that out, we'd greatly appreciate it, as it does help us with future programming and events. And then lastly, thank you to everyone for participating and making tonight what it turned out to be. And so thank you all very much and have a good evening.